In this lesson, we are going to learn about mens rea. Mens rea. An act becomes crime when it is committed with evil intention. Evil intention or guilty mind is essential to commit a crime. Otherwise, a person cannot be held liable and punished. Mens rea is based on well-known maxim actus non facit reum nisi mens sit rea, which means act does not make a man guilty unless his intentions were so. मेंसरिया में जो है जो क्राइम करता है आदमी उसका इंटेंशन देखा जाता है। अगर उसका इंटेंशन क्राइम करने का है तब तो वो पनिश किया जाएगा। अगर उससे गलती से हो जाता है या उसका इंटेंशन नहीं है तो वो उसको मेंसरिया का लाभ मिल सकता है। Earlier in English criminal law there was no distinction between crime and tort. Criminal law was based on strict liability and punishment on those days were mainly in form of money compensation. Therefore, mental element in crime was irrelevant. But later bodily punishment came in substitute of damages. Now from here mens rea got importance. Mental element in crime was recognized as at this time. With the passage of time, mens rea became important element in deciding crime. पहले जो है टॉर्ट और क्रिमिनल लॉ में ज़्यादा अंतर नहीं होता था क्राइम और टॉर्ट में, बिकॉज जो है मनी कंपनसेशन के फॉर्म में जो है मतलब कि उसमें जो है फाइन होता था ज़्यादातर। लेकिन जब से बॉडीली पनिशमेंट यानी कि इम्प्रिजनमेंट या डेथ पेनल्टी ये सब चीज़ जब आ गई तो यहाँ पर मेंटल एलिमेंट को देखना ज़रूरी हो गया कि वास्तव में क्या वो उसका इंटेंशन क्राइम करने का है या नहीं। For any criminal liability, act should be voluntarily committed. No person can be held liable for an act done under any fear or compulsion. For example, A points revolver to B and say to open the lock of C's house. Here B's act is not voluntary, but it was against his will. Intention and motive is different element in crime. Motive may be good or bad, but if intention is wrong, then person is held liable for crime. For example, if A steals bread from shop due to hunger, here motive is good, but still he will be held liable for stealing. उसका मोटिव तो यहाँ गुड है बट उसका इंटेंशन जो था चोरी करना था, इसलिए उसको लाइबल किया जाएगा। Following are some important cases of mens rea. In R versus Prince, Prince took away a girl below 16 years of age from the possession of the father of a father and against the will of her father. Prince argued that the girl told him that she was of 18 years and intention was bona fide as she was looking like 18 years or above. In this case, court has held that he cannot be given the benefit of doctrine of mens rea because this is the case of mistake of law. Taking away a girl below 16 year is unlawful, hence he was held guilty. In R versus Tolson, Mrs. Tolson's husband was lost in vessel. She and her father made reasonable inquiry about Mr. Tolson, but they couldn't find him. With an honest belief that her husband was dead, Mrs. Tolson married to another person. After some time, Mr. Tolson returned and sued Mrs. Tolson for marrying before 7 years of desertion. In this case, court has held that she has made reasonable inquiry with bona fide intention that her husband was dead. Therefore, she is entitled for the benefit of doctrine of mens rea. यहाँ पर जो है मिसेस टॉल्सन को डॉक्ट्रिन ऑफ मेंस रिया का लाभ दिया गया, hence she was not guilty. In state of Maharashtra versus M.H. George, M.H. George was a passenger to a Swiss plane who was going from Zurich to Manila. When the plane landed in Bombay, Custom Department recovered 34 kilos gold bar from him. In India, bringing gold without permission of Reserve Bank of India was not permitted. He argued that he was not knowing the rule and benefit of mens rea must be granted. In this case, court has held that it is the case of strict liability, and if benefit of doctrine of mens rea is given, then it will encourage smuggling of gold. Hence, he was held guilty. MS जॉर्ज जो है वो ज्यूरिक से मनीला आ रहे थे। बीच में प्लेन जो है किसी कारणवश बॉम्बे में लैंड कर गई और उनको नहीं पता था कि ये प्लेन बॉम्बे में लैंड करेगी, बट यहाँ पर उनको डॉक्ट्रिन ऑफ मेंसिया का लाभ नहीं दिया गया। In Nathulal versus State of MP, Nathulal, who was a stockist of grain, he was charged of selling grains without obtaining required license. He argued that he had already applied for license and deposited license fee accordingly. He has given all the information of his purchases to the local officials. चूंकि उसने ये सारी इन्फॉर्मेशन भी सारी दे रखी थी, एप्लीकेशन भी दे रखा था, लाइसेंस फीस जमा कर रखी थी, तो ये माना गया हिज इंटेंशन वॉज नॉट टू इवेट टैक्सेस. In this case, court has held that his intention was bona fide, hence he was not liable. In Shiraz versus D. Rudson, ये भी बहुत important case है. The daughter of a bar owner served liquor to a constable who was off duty and not wearing belt and badges. In this case, court has held that intention was bona fide, hence she was not held liable. किसी सरकारी आदमी को लिकर सर्व करना उसके ड्यूटी आवर्स में ये गैर कानूनी था, बट चूंकि कांस्टेबल ऐसा लग रहा था कि ऑफ ड्यूटी है, वो न बेल्ट पहने था न बैज पहने था, तो इसलिए जो है यहाँ पर डॉक्ट्रिन ऑफ मेंसिया का लाभ इसको दिया गया, बार ओनर के गर्ल को. Applicability of mensia in IPC. Law in India is codified and offences are carefully defined. Mensia can be seen in Indian Penal Code in two ways. First, the chapter dealing with general exceptions, and secondly, every offence in Indian Penal Code is defined very carefully and precisely to include the evil intent. This has been done by using words such as voluntarily, intentionally, knowingly, dishonestly, fraudulently, negligently, etc. तो इन सब वर्ड से ये पता चलता है कि इंडियन पीनल कोड में जो है मेंस्ट्रिया को भी इम्पोर्टेंस दिया गया है. इफ द लेजिस्लेचर हैव ओमिटेड द मेंटल कंडीशन, देन इट इज जनरली प्रिज्यूम्ड दैट द डॉक्ट्रिन ऑफ मेंस्ट्रिया विल नॉट बी एप्लीकेबल इन सच केसेस. In cases of strict liability and vicarious liability, generally mensia is not applied. Wish you happy learning.
Please like this video and don't forget to subscribe this channel. It is totally free. Thank you.